Well, good afternoon, everyone, and welcome to the next webinar in the series of Let's Talk About Corporations. My name is Jason Harris. I'm Professor of Corporate Law at Sydney Law School. I'm also the Director of the Ross Parsons Centre for Commercial, Corporate and Taxation Law at Sydney Law School, and I'm delighted to be speaking at this particular webinar. Today's commentator, I'm delighted to have Vanessa Whittaker SC, who's a commercial silk at Banco Chambers here in Sydney, and she specialises in corporate and insolvency work. So we've only got about a third of the people who've registered have currently logged online so far, but we do have some 60 odd people online, so we might just get started just in the interest of time. In terms of housekeeping, if you do have any questions during the discussion, if you could post those in the Q&A box, which you should see on your Zoom toolbar, and we will allow about 10-15 minutes at the end of the discussion to go through any questions that might be raised. So if you do have any questions as we're chatting about this interesting issue of accessorial liability, please post them in the Q&A box. The other point that I would note is that the session is being recorded, and so a link to the recording, which will be posted up on the UQ and Sydney Law School websites, will be sent out to the registered attendees. So you will have a copy of the recording. And I'm happy to distribute my slides as well from the talk. Okay, so we might get started then. So the topic for today is rethinking accessorial liability in corporate law. And just to give a little bit of background to this series of events called Let's Talk Corporations. This is the third event in the series. We had a webinar about a month ago, which was looking at rethinking federal civil enforcement agencies. And we had an in-person event at Sydney Law School a couple of months ago where we were looking at, the fallout from some of the scandals that we've had with some major corporations. The overarching theme of this program of events, which is a joint program between Sydney Law School and the TC School of Law at the University of Queensland, is really to give a platform for the academics at both of our institutions to share some of the research that they've been doing on aspects of corporate law and corporate liability. And many of the sessions really are targeted at the theme of rethinking aspects of corporate law and corporate liability. So today's topic, rethinking accessorial liability in corporate law, is a topic that I've been interested in for many years. I can remember writing a paper about 15 years ago, I think, in the Company and Securities Law Journal, looking at accessorial liability for company directors with respect to continuous disclosure breaches. So it's a topic I've been interested in for some time. And my interest in this particular area is focused on how corporate law imposes liability for decisions that result in a contravention of the statute. So I'm primarily focused on breaches of the Corporations Act, but how that liability can be shared between multiple persons who are involved in that particular decision-making process. So the papers that I've done in the past, and really the focus of today's topic, is thinking about how we should balance that liability. Clearly, the company can be liable for contravening the law, but there's then the broader question of who, apart from the company, should also be liable for that particular contravention. And the angle that we're going to focus on today is accessorial liability. So let's start with different forms of liability that can arise in this context. So we're going to focus on number 4, which is accessorial liability. But aside from accessorial liability, and even though I know a number of people on the line today have a legal background, I'm not assuming that everyone is a corporate lawyer, so I'll go over a couple of basics before we get to the core topic of accessorial liability. So clearly, an individual who is working for a company or working with a company can themselves be a primary contravener in addition to the company contravening the respective provision. It's clear that just being a director, for example, of a company who causes the company to engage in conduct does not stop the person who's doing that, let's assume it's someone like a managing director, it does not stop them from being a person who also engaged in the conduct. And One of the cases that I've referenced there is the Citro Fresh case. This is something that I've written a little bit about. This was quite an interesting case about a managing director of a ASX listed company who caused the company to engage in some scientific tests of particular chemicals that were used in the company's product, and then based on those medical test results drafted up a press release that basically said the company's product would stop the global spread of AIDS and SARS and the common cold and all sorts of different diseases, even though the person was not a medical expert in those particular areas. Now, what intrigued me about this case is, again, this interplay between the different roles that a variety of people have inside a company, and in this case, the relationship between the managing director who was drafting the press release or had primary responsibility for drafting the press release, together with the investor relations team, together with the other directors who were informed of the press release before it was released, and the role of the company secretary, who was actually the person who lodged the press release with the ASX. And in that case, the federal court found that the managing director, because he had drafted most of the press release himself, that he was making those representations. He was a primary contravener. So the company clearly was liable, was the company's press release, but because he wrote it, he was also a primary contravener. Now, this distinction between being a primary contravener and being an accessory to someone else's contravention is one of the critical issues for today's discussion. Because what we see in the law, and some particular provisions we're going to focus on, including provisions like misleading or deceptive conduct, don't require any particular knowledge or intention to be established in order to found a contravention. What we will see is that the accessory liability provisions, that you are in effect helping someone else to contravene the law, they do have a knowledge requirement. And if you take anything from this discussion today, it's that knowledge requirement is in fact very difficult to establish, that it's very complicated, and in some areas we might say it's actually inconsistent with other areas of the law. So that's really the overarching theme for today. Now, I'm primarily focused on civil liability, and particularly liability under the Corporations Act. That's my area of research. I'm not going to go into any detail about corporate criminal liability and the criminal code, although it does get a mention on a couple of the slides. So what we're not talking about here are things like conspiracy to commit contraventions, for example, where multiple people are coming together and basically agreeing to engage in contravening conduct. We're not going to be talking about that. We're talking about the company contravening a provision, let's say the Corporations Act, and then who else can be liable for that as an accessory. Now, aside from being the primary contravener, you are the person that did it, so you are therefore liable. We do also have provisions in the Corporations Act that we might say impose negligent forms of liability, that the company has contravened the law and you are liable because you failed to prevent the company contravening the law. Now, we're not describing that as being an accessory. It's a separate contravention. You had a statutory duty to usually take all reasonable steps to prevent the company from contravening the law, and you failed to do so. The easiest example, and in the example that we've seen come out in some of the cases, is Section 344, which deals with the director's liability to take all reasonable steps to ensure that the company is complying with its public reporting obligations. And that, of course, was one of the big issues in the Centro director's duties case from about 10 odd years ago. We also have a variety of deemed liability provisions. And this is a fascinating area of the law that the Law Reform Commission has looked at in its corporate criminal liability report from a couple of years ago. We're seeing, if you like, a significant increase in the numbers of deemed liability provisions that are imposing liability on company directors. You're liable because the company contravened the law, and being a director, you are deemed to also be liable for that. Of course, the rationale for these types of provisions is that it then creates an incentives on boards to have in place, hopefully, effective compliance systems, risk management systems, and the like. Some examples could include Section 188, which imposes deemed liability on the company secretary if the company doesn't keep its registered office open at the required hours, for example, or doesn't properly update the company's registers. If the company doesn't have a company secretary because it's a proprietary company, then the directors will have that deemed liability under Section 188. And then we get to the focus of today's talk, which is accessorial liability. So the essence of accessorial liability is that it is derivative of the primary liability. So someone else has contravened the law. For the purposes of today's talk, we're going to assume that that's the company that has contravened the law. And the question is, has anyone else helped the company to engage in that conduct to such an extent that we can say that person should be liable as an accessory? Now, of course, we can have a very large company that's got a lot of people working for it and working within it. We can also have a one-person company or a closely held company that's one or two people might be performing all the various functions inside the company. The High Court has made it very clear that just because we can say that you are the so-called directing mind and will of the company, that your knowledge, intention is to be attributed to the company, that does not prevent you from also being an accessory. So we can have a situation where your conduct as an individual causes the company to contravene the law, so the company is the primary contravener, but you are also an accessory to the company's contravention, even though it's your conduct, it's your knowledge, it's your intention which has caused the company to contravene that specific provision. So in Hamilton and Whitehead, the High Court made it clear that you as an individual can be both the directing mind and will for attribution purposes to cause the company's conduct to be found to be in contravention, but you yourself can also be an accessory. However, just because you are the directing mind and will, that does not mean necessarily that you will be an accessory. It depends on the circumstances. And so the most recent appellate case that's looked at this issue was the Mayfair case that you might have read about or heard about in the press, Marwini and Asic in the full federal court, where the full court said that just because you're the directing mind and will, that in and of itself does not make you an accessory. There is more that needs to be proved there. And what we'll see is the more that needs to be proved is the knowledge requirement, which we're going to spend a bit of time talking about. Now, of course, there are a variety of accessorial liability rules that we find in both public and private law and in statute law. I'm not going to be talking about those. We're not going to be talking about Barnes and Addy. We're not going to be talking about accessorial liability in tort. If you are interested in that, I would recommend to you an excellent book, which was published in 2015 by Dietrich and Ridge from the ANU, which you can find on accessory liability in private law. Okay, so let's then focus on the Corporations Act. We know what we're talking about, which is accessorial liability. We're going to focus on the statutory form of accessory liability under the Corps Act, and that basically is found in Section 79, which is a definition provision, and that then defines the phrase to be involved in a contravention. And what we see throughout the Corporations Act is a variety of provisions that say you must do this or you must not do that. And if you've contravened that provision, you're the primary contravener. And then usually in a subsection 2 or a subsection 3, it will say a person who's involved in the contravention also contravenes this provision. And what I've done there is basically list the various provisions for you. So we've got the director's duties provisions, although notably not the duty of care. So we have 181, 182 and 183, which are the kind of statutory equivalents to general law fiduciary obligations. We have provisions dealing with the related party transaction rules in Section 209, provisions dealing with unauthorised capital reductions, providing financial assistance in a way that's not authorised by the statute, engaging in transactions that have the effect of delaying or hindering the payment of employee entitlements, provisions dealing with managed investment scheme officers and employees, fundraising provisions, liability provisions, particularly banning orders relating to providing financial services, and then general misleading or deceptive conduct. I would also note that following changes in 2018, Section 1317E was amended. 1317E, which many of you would know, is the provision in the Act that sets out here are all the provisions in the Corporations Act that are designated as civil liability provisions. And a new subsection 4 was included, which then makes all of the civil penalty provisions in the Act to have accessorial liability, which is not something that previously existed. Before we look to the terms of Section 79, I'd just point out also Section 83, which also specifies if an individual officer or director is listed in relation to a contravention, then that person contravening it is taken to include a person who is involved in the contravention. So my point here is the concept of accessorial liability under the Corporations Act is throughout the Act. And indeed, what we would see, for example, if we had a look at the ALRC's Corporate Criminal Responsibility Report from a couple of years ago, they actually did some statistics and had a look at a whole range of federal and state law statutes. And this concept of statutory accessorial liability is in fact pervasive throughout Commonwealth and state statute law. So this is a pretty important concept. All right, let's then have a look at Section 79. So if there's a provision in the Act that says a person involved in the contravention also contravenes this provision, how do we know if a person is involved in the contravention? We look to Section 79 for the definition. Now, the one point I would make here, and this has come up in some cases, is that Section 79 does not, in and of itself, impose any liability. It's a definition provision. So we can't say that a person is liable as an accessory under Section 79. They are liable as an accessory under the other provision in the Act that says a person who's involved in the contravention also contravenes the provision. So Section 79 is only a definition provision where accessorial liability is already provided under the other section. Now, we're going to go through each of these paragraphs in just a moment. So I won't read through them in any great detail. Person is involved in a contravention if and only if they've done one of these things, basically. They've aided, abetted, they've induced, procured, they've conspired with others to effect the contravention, or they've been knowingly concerned in the contravention. And in fact, we're going to spend most of our time looking at Section 79C. Now, this definition of involvement in the contravention, I should note, also applies in the ASIC Act. Pursuant to ASIC Act Section 5 subsection 2. There's also a specific wording in relation to being an accessory with respect to the statutory injunction provision in Section 1324 subsection 1. Interestingly, that provision includes these terms but does not use the phrase involved in the contravention. So that essentially, if a person is aiding, abetting, counselling, procuring, etc., a person to breach the Act, then ASIC can go off and get an injunction under Section 1324, subsection 1, against that person. But it doesn't use the term involved in the contravention. All right, so where does this come from? This has been in our law for a long time. Usually we would trace it back to the Trade Practices Act, the old Section 75B. As many of you on the call would know, that was then renamed in 2010 as the Competition and Consumer Act. And what we now have in that legislation are two different regimes, although they're virtually identical, for accessorial liability. So we have accessorial liability in relation to the competition law issues, which is still in Section 75B, which is still a definition provision. So if you've got a right to sue for damages or something, then you've got the ability to extend that claim against a person who's involved by reason of the definition provision in 75B. If you're looking at a consumer law contravention, then again, we have the definition that will include persons involved in the contravention in Section 2. However, this concept of being an accessory really goes back to the criminal law. We do have an accessorial liability provision in the Commonwealth Criminal Code in Section 11.2, although I would just point out that that provision is narrower than the Section 79 civil liability provision in the Corps Act. It's narrower in the sense that it does not include the concept of being knowingly concerned in the contravention. That provision itself has a long lineage which goes all the way back to the 1860s in England. So this concept of being involved in the contravention, this is just a rough search that I did earlier this week, put that term into the legislation search engine in Ostley, and I got more than 1,600 hits. So this is a pretty important concept in both state and federal law, although we're just using the Corps Act as our focal point. All right, so we might start with the question of, why do we need accessorial liability? We've already got provisions that provide for the primary contravention. Why do we need accessorial liability? Justice Black, who's a judge of the Supreme Court here in New South Wales, he wrote an excellent paper 10 years ago in the CSLJ, where he looked at one of these issues in his paper. And he listed a variety of potential reasons or justifications for why we have accessorial liability. And what we might say is that accessorial liability is trying to set a regime which is going to encourage people who might otherwise assist the company to contravene the law to basically not do that. So it's then saying, well, if you help the company to contravene the law, then you yourself can also be liable for that. So knowing that in advance, then maybe you won't help the company to contravene the law. It also, of course, has a compensatory purpose. And this is where we see private actions against directors, for example, or indeed against professional advisors, which we'll come to a little bit later. So if the company is engaged in misleading conduct, the company gets sued. What if the company doesn't have the money to pay the judgment order? The company goes into liquidation, and so maybe there's a claim against persons who were involved in the contravention, which is permitted under the statutory misleading or deceptive conduct provisions. So it broadens the scope for claiming relief in respect of the contravening conduct. What then is the relationship with the primary contravention? So accessorial liability is described as being derivative of the primary contravention. There has to be a primary contravention. But that doesn't mean that then the primary contravener needs to be found in a separate proceeding, or indeed to be joined in the existing proceedings to have actually been found to have contravened the law. So the court, and the cases do unfortunately go both ways on this, but I would suggest, and perhaps my commentator at the end might share their view, I would suggest that the courts are saying you don't need a separate ruling against the primary contravener. And indeed, in some of these cases, I can't remember if it was the Matheson case or it was one of these other ones, that the company that engaged in the contravening conduct had actually been fully wound up by the time the accessorial liability proceedings got to court. So the company actually didn't exist anymore. So it is possible to just sue the accessory, but the liability of the accessory does depend on there being a primary contravention. And so it may well be that the court needs to make a finding in the proceeding against the accessory that there has in fact been a primary contravention, but they don't need to make orders against the primary contravener. And you certainly don't need to join them to the proceedings. What these cases do say, however, is much of that might depend on the given circumstances. So in the Matheson case, the court made it clear, look, there'd be no point joining the company because the company's insolvent. But there might be other circumstances where maybe you should be joining the company, even though your primary target, as it were, is the accessory. All right, so let's then go through section 79. What are the different elements? As I say, we're going to focus on 79 subsection C, which is being knowingly concerned in the contravention, either directly or indirectly. Starting with paragraph A, so can we say that the person has aided, abetted, counselled or procured the contravention? The courts generally say that aiding and abetting is referring to someone who is acting at the time of the primary contravention, whereas counselling and procuring is usually seen to be something which occurs before the contravention occurs. But I'm not suggesting that it has to be that. And indeed, many of the cases say, look, a lot of these different words are really referring to the same thing. They're referring to someone who is helping the primary contravener in order to engage in the relevant conduct. So we don't necessarily need to drill down into the detail of, well, is it aiding or is it counselling? But the old case there that I've mentioned, which does get cited quite a lot, Acting Chief Justice Cusson in R and Russell, talking about the different temporal elements. And His Honour, in that case, he went back to some older criminal law cases. It is clear, and there's a reference to the High Court's decision in York and Lucas, which is undoubtedly the most important case that we've got on this particular issue with respect to civil liability. It was a misleading or deceptive conduct case we'll come back to in a minute. In that case, the High Court focused on paragraph A and also paragraph C, albeit in the context of the Trade Practices Act, but did make it clear that the level of participation needs to be intentional. You need to know that you are assisting this person in some way, even though you don't need to know that you're assisting them to necessarily break the law, although we'll come back to that. So aided, abetted, counsel or procured, that is pretty much on all square with general criminal law principles, and indeed that wording appears in criminal law statutes, including in the Criminal Code. Paragraph B, the person is induced, whether by threats or promises or otherwise, the contravention, and I've got a reference there to a couple of different cases, including an older case, just making it clear that, yeah, it can be by way of threats, but it doesn't have to be that. So it can actually be, I think in the Short and Citibank case, Justice Street described it as, kindly persuasion can still satisfy this, that you're doing something that, I guess, with the intent to try and encourage the person to do something else, whether you're threatening them, if you don't do this, this will happen, or whether you are in fact just being something more like a cheerleader, trying to encourage them to engage in this conduct. The reference here that I've got, the quote that I've got from the State Street Global Advisors case from 2 years ago in the federal court, I think is important. It's not enough for the alleged wrongdoer to know that a breach may well happen, or that the breach is the natural and probable consequence of the alleged wrongdoer's activities. They must take some step which manifests an intention to induce the breach. What must be shown is some persuasion, encouragement, assistance, or pressure that is aimed at the contract such that there is a clear causal link between the respondent's conduct and the breach. I just want to emphasize that, because when we're thinking about people who are involved in corporate decision-making processes, if we think about the context of a board meeting, for example, clearly we've got the directors who are there sitting on the board, they're making decisions as the company. But in many board meetings, there's going to be lots of people in the room who aren't just the board of directors. So we'll have the company secretary, we might have some other corporate executives, we might have legal advisors, we might have general business advisors, consultants, mid-level employees and the like. And this is really the question that I'm most interested in, is how then do we distribute liability amongst that broad group? Where do we draw the line to say that, well, this person's participation isn't culpable enough to justify imposing liability on them? So I think that's quite important, is just knowing what the consequence is isn't enough. You need to be an active participant in the conduct. You need to be helping them in some way. The idea of a causal link between what you are doing and the primary contravening conduct. All right, now I'm skipping paragraph C because most of the rest of the slides are about paragraph C, and I'll just quickly cover paragraph D of section 79. The person has conspired with others to effect the contravention. So in the Vantage case, the WA Supreme Court says, must be proved that a person was a party to an expressed or implied agreement to carry out the unlawful act. Now, there was an appeal in that case, but it didn't affect this particular issue. All right, so let's then focus on the main topic of being knowingly concerned, directly or indirectly, in the contravention. This undoubtedly has given rise to the most controversy in the cases. This has been described by Justice Brereton when His Honour was on the corporations list here in the New South Wales Supreme Court, that Section 79C is undoubtedly the widest of the four different concepts. Now, I put that in there because there is a counter view in cases and also in some of the scholarly commentary. So there are some who say, well, look, really all of these different paragraphs are basically talking about complicity in criminal law, and the idea of aiding and abetting, counselling or procuring, they're really just different ways to say that. And I've got a reference there from the Investors Forum case, Justice Palmer, who basically takes that view. That's quite different to the view that Justice Brereton has taken, and if anything, I would say the view of Justice Brereton probably is the predominant view these days. Interestingly, in the criminal case of the Crown and Campbell, Acting Justice Weinberg, Acting Judge of Appeal Weinberg, talked about some of the background with the development of the Commonwealth Criminal Code. And he talked in particular about the exclusion, the deliberate exclusion from Section 11.2 of the knowingly concerned in category. Basically saying, no, it is meant to be something different. It's meant to provide for a circumstance where we can't say that aiding or abetting or counselling or procuring is available. All right, that then brings us to York and Lucas, which really has set the stage for how the law has played out on this issue. So this was a pretty standard misleading or deceptive conduct case. We had a sale of a business. We had a corporate vendor who was selling their business. They had inflated the sales figures and the profit figures for the business to try and get a better price. They were working through a sales agent, which was Mr. Lucas. Technically, his company, Ross Lucas Proprietary Limited, was Mr. Lucas himself that made the representation to the purchasers, who were the Yorks. And in the circumstances, the court was not prepared to find that Mr. Lucas had any knowledge that the information that he was providing about the sales figures was in any way false or indeed misleading. So in this case, they found that clearly the vendors had engaged in misleading conduct, but in this case, Mr. Lucas and his company had not engaged in misleading conduct because they were not aware that the information was false or misleading. And this might be seen to be one category of case of what we could call the kind of mere conduit argument, that you are passing on information, but you are not yourself making that representation. You are not adopting or approving of that. You're just passing it on. It's someone else's information and you are passing it on. And here we have the key statement, which then gets cited hundreds and hundreds of times in the cases that follow York and Lucas. There can be no question that a person cannot be knowingly concerned in the contravention unless they have knowledge of the essential facts constituting the contravention. Then I've got a reference here to the Gore case, which is one of the recent full federal court cases. This was about several companies that were engaged in illegal fundraising, offshore fundraising, supposedly in the private placement markets offshore. And the question was whether the director of the company, who was a party to a marriage, and her husband was not technically a director, although he appeared to be actually running the company. He was a paid consultant of the company. And the question was whether Mrs. Gore, who was the director and also a major shareholder, whether she was knowingly involved in the company's contravention. Basically, they did things that required issuing prospectuses and they didn't issue a prospectus. And in this case, the full federal court found, yes, that the nature of her involvement in the company, it wasn't the fact that she was just the director or even the main director of the company. It was the fact that she had an active role in drafting some of the documentation, in deciding what went into the information memorandum, that she had also been copied into correspondence directed at her husband and from her husband about some of the details of the transaction, and in particular about the fact that they knew that they were not complying with the law. That basically they're saying, look, we are not registering any of these securities under domestic or foreign law, and they actually put that in big bold lettering. And so the court used that to say, well, in this case, clearly she was aware of what was going on. She had sufficient knowledge based on her conduct and what she was being told to be found that she was knowingly concerned in the contravention. All right, then I've got a reference there to a more recent case that some of you might have read about in the papers, the Get Swift litigation, which was about breaching continuous disclosure laws and misleading and deceptive conduct. And again, we see the court referring to the need for some sort of connection, some sort of link between the act of the accessory and the underlying contravention. In this case, the link was the three individuals who were directors who were out there actively spruiking the company's financial prospects and the supposed profit projections based on contracts that the company had supposedly entered into, even though that information was misleading. Right, now I'm just mindful of the time. There's a couple of other points I want to get to before I hand over. So going back to the High Court's statement in York and Lucas, so what knowledge is required? Well, knowledge of the essential facts. The general law accessorial liability rules usually draw a distinction between circumstances where the primary contravention has a knowledge or intention component to it, in which case the accessory needs that, and where the primary contravention does not. And it's very clear that the High Court's decision in York and Lucas means that for statutory involvement contraventions, you need knowledge, even if the underlying provision, the primary contravention provision, does not have a knowledge requirement. It's essentially strict liability. Now, of course, that's, I think, profoundly interesting, because the outcome in York and Lucas was such that Mr. Lucas was not liable because he didn't know it was misleading. And yet the High Court is saying, well, you need to have knowledge of the essential facts. It's clear that you don't need to know it's illegal. But when we're looking at misleading conduct, do you need to know that it's false? And this is where the law gets really tricky, because there are cases going both ways. There are some cases that say, well, you're not an accessory because you didn't know it was false. That's York and Lucas. But there are other cases that say, you don't need to know that it's false. You need to know that the representation was made. That's the essential fact, because the underlying primary contravention provision is essentially strict liability. It doesn't matter whether you knew it was wrong or not. You might have believed it was true. And in misleading conduct, of course, it's the effect of the representation on the relevant intended audience, rather than the intention of the party who's making the contravention, who's engaging in the representation. So this concept of, well, you don't need to know that it's wrong, you don't need to know that it's illegal, that of course has been applied in many subsequent cases. Horton and Arms is quite a significant High Court case where mid-level employees in a computer company that was helping clients set up websites, they made representations about what the company's software could do. Those representations were incorrect. They didn't know that the representations were incorrect, although in that particular case, they were found to be primary contraveners. And so the court actually didn't need to determine the accessorial liability, but they did apply these wording from York and Lucas. And then the more recent reference there to Gore and Asic in the full federal court. It's clear that the knowledge has to be held at the time of the contravention. So if you didn't have the requisite knowledge when you were supposedly assisting the person and you then later acquire the knowledge, that's not going to be sufficient to find you as an accessory to the contravention. This is a topic, I should say, that comes up quite a lot in workplace disputes. So I've got a reference there to one of the employment cases. I might skip over that just in the interest of time. The High Court criminal case in Georgiani, which was decided in the same year as York and Lucas, the person charged must have intended to help, intended to encourage, intended to induce the principal offender to bring about the forbidden result. Again, focusing on this issue of what is the causal connection between what the accessory is doing and the intended result from that in terms of the primary contravention. It's very clear that knowledge in this context is not constructive knowledge. So it has to be actual knowledge. However, that's, again, when we get into the murky waters of, well, what about willful blindness? What about in a circumstance where the supposed accessory is aware of what's going on and they deliberately try to avoid acquiring the relevant knowledge? The court has said yes, that can be, as a matter of judicial inference, that they had the requisite knowledge, but it's not constructive knowledge. So it's not a reasonable person in the circumstance would have known this. It's what did you know, and then based on all the circumstances, what is the court satisfied that you knew at the time? And the High Court's decision in Pereira gets cited quite a lot on this point, that we can look at all the circumstances, and when confronted with the obvious, the person deliberately tries to avoid acquiring the knowledge. The Adler case is quite an important case in this, also known as the HIH case, back from 2002. In that case, there were multiple contraventions. Some of the relevant ones related to the related party transaction provisions and also stock market manipulation. And the court also found there, in this case, Justice Santo, who's a former Chancellor of Sydney University, knowledge of potential conduct isn't enough. So what we're seeing in the cases is really a distinction between a person who knows what could happen or knows what is happening. They're not going to be an accessory unless they do something that then provides that causal link. So it's not enough to just be a mere bystander. You know what's happening, but if there's no existing duty on you to act, well, you're not going to be an accessory. And if there was a duty on you to act, you wouldn't need to be sued under the accessory provisions anyway. You'd be sued for failing to comply with your individual duty. So knowledge of the misconduct is not enough to make you an accessory. But again, we come back to this point. Well, it's knowledge of the essential facts. That's going to be different depending on the primary contravention. All right, the essential facts may well be different depending on the particular area. So continuous disclosure, which many of you would know was significantly amended, 18 months ago to include a fault element, at least for civil liability provisions, misleading conduct, section 1041H, and then also breaches of director's duties. And I think the breach of director's duties one is one of the more interesting categories, because if we're thinking about the section 181 or 182 or 183, really that it's talking about the conduct of the director is not acting for a proper purpose. They're not trying to benefit the company, they're trying to harm the company's interests, or they're trying to benefit someone else, which might be themselves or might be someone else. So there are cases where someone is said to be involved in the director's contravention. Adler is a good example, where Mr. Adler's family company, which he controlled, was an accessory to his breaches of director's duties. In the Hydracool case, this was quite an interesting matter, where basically the managing director was trying to engineer a management buyout of the company, and so was conspiring with one of the major suppliers of the company to put the company in a position where he would be able to basically take over control. And a senior executive who was not an officer of the company, though, was helping him to do that by doing things like drafting public announcements, drafting emails, reviewing documents, and that was found to be knowingly concerned in his contravention. Okay, I'm just mindful of the time. Bringing it back to directors and whether directors can be accessories to the company's contravention, I think it's very clear that just because the directors are present in the room while the conduct is being discussed or engaged in, that's not going to be sufficient. It's very clear, going back to the Maxwell case, which was Justice Brereton that we referred to a moment ago, just being a director of the company that contravenes the law does not mean the director has been an accessory to the company's contravention. However, what if the directors are approving of the conduct, for example, by passing a board resolution, which then authorises the conduct, even though the directors don't know that the conduct is unlawful? Arguably, that's going to be sufficient to make the directors accessories to the company's breach of the law. And of course, many on the call would be aware of the so-called stepping stones argument, where the company has breached the law, perhaps a disclosure provision, and then we might question, well, are the directors being negligent, for example, in allowing the company to breach the provision? I think this is a fascinating question. We could probably spend the whole hour talking about this. I've got some views. I suspect others have some different views. What's the effect of a director who abstains or dissents from the board decision? So if we assume, for argument's sake, and there are cases that say this, that if the directors are approving of the board engaging in conduct and that conduct ends up contravening the law, then the directors could be said to be accessories to that breach where accessorial liability is available. So what if a director says, well, no, I don't approve of this, I think this is wrong, I think we might be breaking the law, and then wants that recorded in the minutes? Is that going to be sufficient? So there is some academic commentary that suggests that that will be sufficient, that therefore they can't be said to be accessories because there isn't then that causal link. I guess my perspective is slightly different because of the idea that the board exercises its management power as a collective. And so I don't believe I'm not giving anyone legal advice here, of course, I don't have a practicing certificate, but I don't think it's sufficient to simply say, I'm going to abstain from the vote, or I want my dissent recorded in the minutes. And I don't think we want to get to the position where we're seeing the minutes of board meetings as really being about covering the backsides of directors. That's not the purpose of minutes. It's to record what happened at the meeting, the decisions that were made as the company at the board meeting. The conduit point we've already noted. The Citro Fresh case also ended up in the federal court, full federal court under ASIC and Narain on a particular point, and that one of the points in that case was about whether the company secretary was making the representations, which the court said no, he was the mere conduit. The managing director was the one who drafted the press release. I've got a couple of examples here. I'll be quite quick with some of these examples. Maxwell, which I've mentioned a couple of times, this was another illegal fundraising case, basically, and the court said just being on the board of directors when the company was making misleading statements, particularly through agents, basically marketing agents who were going out and trying to drum up investors, albeit illegally, that was not enough to make the director liable. Gore and ASIC I've already mentioned, so I might skip over that one. ASIC and Select AFSL, this was about improper remuneration under Chapter 7 Financial Services, and the company was liable for paying improper remuneration, basically volume-based commissions. But the sole director of the company who approved of that plan and actively promoted the plan was found to be an accessory of the company's contravention of those provisions. And Get Swift I have already talked about. One of the interesting points in Get Swift was deliberately ignoring the legal advice that the company had from its internal lawyer, and basically the managing directors trying to bypass the company's in-house counsel. And they were then accessories. Hydrocool I've already talked about. ASIC and Somerville is one of the more interesting cases. This was about Phoenix activity, basically directors of companies that had incurred debts like tax debts or work cover debts or creditors who were suing them, going off to a lawyer, Mr. Somerville, and basically saying we don't want to pay the debts, and then Somerville setting up Phoenix companies. And interestingly, Somerville was the primary defendant in the case. He was a solicitor in North Sydney, and clearly that was the focal point of ASIC's litigation in this particular matter. Now his counsel said, look, if he's just giving legal advice, how can he be an accessory? And I've extracted the full quote here because I think this is really very important. The court's saying, okay, in the normal course of proceedings, legal advice isn't going to be giving rise to accessorial liability, but if the advice that you're giving is clearly to break the law, then that might be different, which it was in this case. Now, I've got another case there, an older English case, where the solicitors were drafting documents that contravened the law, but the solicitors were not aware of what the documents were being used for, and therefore were not found to be accessories. This is just a quote from Bednall and Hanrahan's paper in the CSLJ, just noting this whole area of the law is complicated, unsettled, incoherent. The term dog's breakfast springs to mind. I just thought that was a nice point to try and sum up here. The last two slides are talking about potential reforms and some policy concerns. One of the big issues here is, of course, this area is really complicated, does really warrant a rethinking, but that's broader than just accessorial liability. That really what we need here is not personal liability being tacked on to some other public inquiry, which is basically what we've seen. We need a broader review of personal liability laws, because we're only focused on the Corporations Act in this talk. There are hundreds of statutes that provide variations of these principles that we've been discussing. Sometimes the wording is the same, sometimes it's not. Sometimes there's defences, sometimes there's not. Sometimes there's a reverse onus of proof that's imposed. So this area of law really is a mess and does warrant its own separate inquiry looking at personal liability of individuals. I've gone a little bit over what I was hoping to talk about, so I'm now going to pass over to our commentator, Vanessa. Vanessa, what's been your experience with litigation and accessorial liability?
Jason, I salute your ambition for trying to cover either this topic or that question in an hour. But can I just say that I'm energized by your enthusiasm for this topic. I've caught it a little bit, it's contagious. But what you've asked me to sort of comment on from a practical or practitioner's perspective is your summary in this paper, which I should confess now I'll be putting in my top drawer to contribute to reducing my own workload when I'm providing advice. But in short, and obviously with respect, I wholeheartedly agree with what I take at least to be your overriding or overarching proposition. Accessorial liability it's very difficult to prove in my experience, and it's also very expensive to defend. And I think the primary reason for that is what you've identified. It's this perfect storm of both legal complexity and indeed legal uncertainty and factual complexity. It comes up all the time because obviously companies act through people, and ultimately when people have a complaint against a company, or a company owes creditors money, for example, ultimately, when you push through the legal fiction of corporations, that complaint is made by and at some level against people. And ultimately, companies at the end of the debt is a debt. It's people who are affected by the actions of companies. And I think that that informs both the appetite of the regulator and also just in civil litigation, when people are bringing complaints against companies, they often want to attach responsibility to an individual, to a human being. It comes up, as I say, very regularly in practice, and I think I'm engaging with something that you've already raised. It's both in the pointy end, the actual litigation about these matters, but also in an advisory sense, and not just responding to the question, am I likely to be liable, but also corporations, particularly bigger institutional clients, wanting to really have those prophylactic systems or safeguards in place to protect against the consequences of the things that you're talking about, and also to stress test the integrity of their current systems. And when you speak about board meetings and board minutes, I think that's a really important conversation, because to come straight to the requirement for there to be an intention or a mental element, and for there also to be a causative relationship between the what's happened and the actions of the individuals. If I can summarize it this way, that causative connection isn't necessarily the same as responsibility. And where that really comes up is in the context of directors, particularly executive directors, who from an internal perspective, in terms of powers and responsibilities of the company, are, speaking really broadly, responsible as a whole. The question is, how does that translate in that causative sense, and also taking into account the requisite mental element? How does that translate into accessorial liability? And they are different questions, and the answer to it very much turns on the facts, which means that when you litigate and when you advise, you really need to have a very close understanding of the facts. In my experience, which is not insubstantial now, dealing with these kinds of issues, the outcomes of the decisions are very merits-based. And part of the explanation for the dog's breakfast is that the principles are, at a broad level, quite easily accessed, and if I can brutally say, they're easy to state, but they're really difficult to apply. And that gives a lot of room for variation in judicial reasoning, analysis, and ultimately conclusion. And so sometimes you have cases where this issue is the outcome of the case creates a precedent, and perhaps when you read the authority, the judicial reasoning isn't as close because it didn't need to be in that case, and practitioners like myself take that reasoning and try and apply it to another case, where often, because of a merits-based approach, a judge applies more scrutiny or analysis to the question, and you get a closer and perhaps different analysis, and therefore a different result. Perhaps finally, I see the time, but I agree with you that you don't need to have a finding against the principal offender, but the entire case in practice, as you say, with respect to accessorial liability, hinges on those findings that there has been such a contravention. So in order to establish or indeed defend an accessorial claim, you need to have a very close understanding of the underpinnings of the primary contravention. I think that's a very quick summary of my experience of it.
Thanks, Vanessa. And I would just add, the ALRC's Corporate Criminal Responsibility Report from 2020 does go into these issues in a little bit more detail. They do have some very interesting statistics about accessorial liability cases that have been run at state and federal level, which do seem to show that we're seeing more accessorial liability cases for larger companies than what we're seeing in smaller companies. And the other point that I would note is they mention in this that they went out and basically talked to prosecutors and various law enforcement agencies who explain essentially what you just said, Vanessa, that establishing accessorial liability is really hard. And so the Law Reform Commission basically held that has contributed to the creation of these kind of deeming liability provisions at state and federal level, that it does just get too hard to establish that someone's an accessory. So what we're seeing in corporate liability, and what very much the ALRC is trying to suggest that we shouldn't be seeing more of, is we want someone to be held accountable, that the company at the end of this process, might be bankrupt or whatever, it might not have the assets to be worth suing or enforcing against. And so a lot of laws will just impose almost default liability on directors, on the assumption that if we impose that default liability on the directors, maybe with a defence or maybe without a defence, in some cases, like I said, a reverse onus of proof, you're liable unless you prove that you've got the availability of the defence, then they will put in place compliance systems. What the submissions to the inquiry talked about, and indeed what the Corporations and Markets Advisory Committee looked at in the early 2000s in a couple of different reports, were people saying, very much as you've said, Vanessa, that this is trying to be a one-size-fits-all, and it's not a one-size-fits-all. That the reality of large, complex corporate groups is completely different. It's another universe from the closely held company. And so having a rule of liability that applies in both cases, it doesn't work effectively in both cases. So that's why the ALRC was saying, rather than put in place these proposals, what we need is a broad inquiry into personal liability, because it is horrendously complicated and multi-layered, not just Commonwealth, but also state law. I'm just mindful of the time. There were three questions, one which I've answered in writing, which everyone should be able to see. Then we had two further questions. One was about from Jock, who's a barrister here in Sydney, which is looking at arguments in voidable transaction proceeding cases where there's an argument that the recipient, or the other side, the creditor, for example, whether they can be said to be involved in the contravention. I guess my 2 cents on that, Jock, would be, obviously it's going to come back to what the precise wording is. One of the things that we see in these cases, and indeed we saw very plainly in the Maxwell case, is this misunderstanding that just because you are involved in the contravention, that you satisfy the Section 79 terms, that means therefore that you're liable. So it depends on the precise wording. I assume, Jock, you're referring to a provision like 588FF and the broad powers that the court can have in those circumstances. So I would not be in favour of saying the court should exercise those to further punish parties to the transaction. Now, if it's something like an unreasonable director-related transaction or an uncommercial transaction or an uncommercial loan, there's already relief provisions to deal with that. One of the things that ALRC talked about, which I found quite interesting, was if the primary contravention is broad enough, do we even need accessorial liability? And indeed, thinking about misleading or deceptive conduct, they actually say this in relation to misleading or deceptive conduct. We shouldn't need accessorial liability because the primary contravention is so broad that the people who are actually actively involved in creating the document that contains a misrepresentation are probably primary contraveners anyway. And that's going to be easier to pursue against them than it is to go after the accessorial liability. Then there's a question from Scott, and we will finish on this point. I'm sorry to take you over 2 minutes. Scott, who's a solicitor in insolvency, talks about, well, what about if there's circumstances with a dissenting director where the general counsel has advised against entering into the transaction and the board ignores the advice and then directs the general counsel to give effect to the resolution? That's a very interesting question, Scott. I would like to think a bit more about that, but my quick reaction to it would be, as a legal practitioner, your highest duty is to the law. And if you're telling the board that, we can't do this, this is going to break the law, and the board is ignoring your advice, I think you've got to think very carefully about whether you want to keep that position. And I would say the same thing to a non-executive director. If you think that what the company's proposing to do is going to break the law, why are you staying on the board? If the board's not listening to you, I do actually think you need to resign, because you're going to be complicit with it by effectuating the transaction. It's not enough, in my view, but there are other views, to be a conscientious objector. I've already taken us a couple of minutes over time, so I apologise for that. Thank you, everyone, for giving up your time today. Thanks in particular to Vanessa, I know you're no doubt involved in busy cases, so I really appreciate you giving up your time today, Vanessa, to share your views.
It's been great. This is highly instructive to me, so I thank you.
Okay, so we'll draw it to a close. If you would like to attend any of the future Let's Talk About Corporations seminars or webinars, you can find the details on the Let's Talk About Corporations website, which is hosted by the University of Queensland. So thanks everyone, and enjoy.